the American with Disabilities Act. The American with Disabilities Act was enacted in July of 1990. It's a law designed to ensure and protect the civil rights of individuals with disabilities. Title I of this act has to do with employment. The information here should help people understand what their civil rights are under the ADA and provide guidance for how to claim these civil rights. The ADA defines disability as a physical or mental impairment that substantially limits one or more life activities. Major life activities include but are not limited to any of the following, and you can stop the presentation and look at these if you want. A disability could also be related to a major bodily function, which includes but is not limited to, and you can stop the presentation here if you want. So, the process of seeking a reasonable accommodation. Under Title I, employers are required to make accommodations to qualified individuals with disabilities to enable them to perform the essential functions of the job. These accommodations must be reasonable and cannot cause undue hardship on the operation of the organization. Now, a reasonable accommodation is any change in the work environment or the way things are usually done to enable a person with a disability to perform the essential duties of the job. Now, what these accommodations are vary with each individual based on the nature of the disability and the essential functions of the job. Every organization should have a contact person for ADA. If working for a larger organization, the first step is seeking an ADA accommodation is to contact the HR office. Now, some disabilities are non-visible. These include, but are not limited to, any of these. When the disability is not obvious, employers have the right to require documentation from a medical or healthcare provider. The only documentation required for this, however, is a letter from the medical or healthcare provider stating what the disability is and how it might limit the employee. Employees should not, under any conditions, sign any form that gives the employer access to any medical information other than that letter. Once a disability has been documented and an agreement has been reached as to the specific elements, the plan is put in place. All medical information is to be kept in a secure location apart from an employee's personnel files. Only qualified individuals should have access to this information. The employer or HR can only disclose information relevant to the accommodation to your supervisor. This includes what the specific accommodation is and how it is to be implemented. HR cannot disclose anything related to the nature of the disability. And under no circumstance can HR or your supervisor disclose, talk with, or discuss the accommodation or related conditions to coworkers, other than to identify what the accommodation is and how it is to be implemented. This is even true if the accommodation is self-evident. To do otherwise is in violation of the federal law under the ADA. After implementation, if a condition is permanent and the employee's needs for reasonable accommodation is not changing, the employer cannot request additional or updated documentation. If the employee is seeking different or additional accommodations, an employer may request new documentation in order to understand the need for the new accommodations. The ADA is a civil rights law designed to prohibit discrimination against individuals with disabilities. For violations of this law, complaints can be filed with the Disability Rights section in the Department of Justice. And here are some sources.